Okay, just another 10 seconds and then we'll begin. Okay, let's get started. Good morning, everybody. Thank you so much for joining us at Support Through Court's Family Law Breakfast. Before we begin, I've just got a couple of Zoom admin bits to run through. So firstly, as you hopefully have just heard, this event is being recorded and will be used for promotional purposes for Support Through Court. There is a Q&A section after we've heard from all of our wonderful panelists. If you would like to engage with the Q&A, and we would encourage you to do so, at the bottom of your screen, there is an icon which says Q&A where you can put through your questions. So please do so. We will be tweeting throughout the event at hashtag FLB2021 at Support Through Court. And we really would encourage you to get involved on Twitter as well. And finally, I just want to say a huge thank you to our sponsors of this morning's event, who are Reya Family Finance, Mischon Reya, 4PB, and our headline sponsor this morning, which is Our Family Wizard. And we're about to hear from James Evans from Our Family Wizard now. So over to you, James.
Thanks, Carmen, and thank you so much to everyone at Support Through Court for inviting us to sponsor today's event. For those of you who know me already, my name is James Evans. I'm the UK representative and professional liaison for Our Family Wizard. And for those of you who don't know Our Family Wizard, we are a co-parenting communication app. We offer a space for parents to communicate through during, before, and after the divorce and separation process. We've been in the UK now for around 5 years, and we've been fortunate enough to see court orders from judiciary in every city of the UK, and we're referred to every day in some case somewhere in the country. Our Family Wizard has a suite of tools available to separating parents that aid and abet their communication and push them in a more amicable direction. We have a message board where their messages are filtered through Tone Meter, which is like a spell check for their emotions, a shared calendar that includes parenting swaps and time events, a info bank where they can share information about the family, like their medical records and their shoe size, their shirt size, that kind of thing, a journal where they can upload pictures and they can geotag themselves and check in, and an expense log where they can track reimbursements. On top of that, family law practitioners can access their clients' Our Family Wizard account and turn all of that information into court admissible reports. Our Family Wizard is the most secure platform available for parents communicating online, and we are so proud to be working with so many wonderful family law practitioners all across the country and fantastic charities and organisations such as Support Through Court. We're going to be hosting a post-conversation chat as well, so if you want to have a chat, know a bit more about us and follow the conversation from today, please do join that. Thank you very much, and I'll pass you over now to the wonderful Barbara Mills QC.
Thank you, James. Thank you for that reminder about Our Family Wizard, and thank you all for joining us this morning at our Support Through Court's Family Law Breakfast. Great to have you start your day with us, as I've said. The cuts to legal aid, increased court fees, and the closure of information services created a bit of an advised desert and left a lot of people going through courts feeling bewildered and alone. Which is where Support Through Courts come in. The wonderful charity that it is pursues its purpose is to provide personal support and assistance without regard to race, gender, sexuality, age, or disability to those going through the court process on their own. The focus of today's discussion is life after lockdown in the family courts. And before I call on our esteemed panelists, let me just give you some statistics to help us understand the scale of the challenge that used to face us and the scale of the challenge going forward. Since 2013, the cuts to the legal aid have meant that the demand for the Support Through Court service has increased significantly. And I'm told that the increase in client contacts is about has gone up about 900% in the last 6 or so years. In the family courts, which is the focus of our discussions today, in the majority of cases, at least one party has no access to legal representation. And this is, of course, in matters relating to separation and divorce, financial arrangements, and contact with their children. Not only are they without legal representation, the statistics show that most of those individuals have also got a multitude of other barriers facing them as litigants in person. 26% have serious health issues, 25% have English as a second language, and 55% are not in employment. In 2019, Support Through Court estimates that more than 500,000 people were unrepresented. So you can see the scale of the difficulties facing the family courts. In 2019 to 2020, 64% of the 78,000 odd clients who contacted Support Through Courts were dealing with, 64% of those clients were dealing with children matters. And last year, in the height of the pandemic, about 15,000 people called for support. So the difficulties facing the courts were real. The pandemic has taken it to a different level, and we will this morning hear from a number of speakers who talk from a number of different perspectives. The first of which is Lord Justice Baker, who is a judge of the Court of Appeal of England and Wales. Lord Justice Baker's focus will be recovery in the courts post-lockdown. So without further ado, over to you, Jonathan.
Thank you very much, Barbara. Can I just hear, Barbara, could you just nod if you can hear me? And I
can.
Great.
Loud
okay.
and clear.
I like the introduction. I like the introduction that you were given. And now he said over to the wonderful Barbara Mills. Do you think perhaps that's how we should welcome counsel in court, Barbara? I should say, and the applicant is represented by the wonderful Barbara Mills, or things like that. Maybe those days aren't quite with us yet. Well, it's a great opportunity for me to talk to everybody this morning. I'm very grateful to Support Through Court for organising this event, because it gives me and everybody else on this panel the opportunity to discuss and raise issues which are really important. So the title of the seminar is Life After Lockdown, Moving Forwards in the Family Courts. And of course, that does involve considering issues that go beyond what's been happening the last 18 months. But I want to focus in the few remarks I'm going to make on the problems which the pandemic in particularly has thrown up. Because as you know, for the last 18 months, I've been assisting the President of the Family Division to plan for the recovery from the effects of the pandemic on the family justice system. And while we've been working together on this, we've been trying to focus on three essential questions. First, how do we achieve a return to court safely and fairly? Secondly, what do we keep from the ways of working developed during the pandemic, and what do we discard? And third, how do we maintain a focus on the well-being of everyone involved in the family justice system? In the early weeks of the pandemic, looking back to February, March of last year, when we thought, or at least hoped, that it would all be over quickly, those questions looked challenging but manageable. As time has gone on and the backlog of cases has grown, and the effects of the pandemic on our ways of working have become more embedded, it's become increasingly clear that the answers to those questions are more complex and interconnected. So with regard to the first question, how do we achieve a return to court safely and fairly? Well, at the start of the new legal year, at the beginning of this month, the Lord Chief Justice has given a very clear direction that all judges should now be back sitting in the court building, whether they are conducting hearings in person or remotely, save in exceptional circumstances. That message was clear and unequivocal. Of course, in some court centres, more cases are currently being listed than we have rooms to accommodate hearings, either in person or remotely. we're using fee-paid judges, that's to say recorders and deputy district judges, to sit alongside full-time judges to try to tackle the backlogs that have grown during the pandemic. In combined courts, of course, as you will know, the Crown Court, which has had to face very grave difficulties in managing during the pandemic, and is now taking up a lot of space, sometimes one or more additional courtrooms for each case. So none of these arrangements can be unpicked overnight. And it's important to stress that no case is going to be delisted as a result of this clear steer from the Lord Chief. And of course, the safety of court users must remain a priority, the priority. Plainly, there are going to be some short-term problems. Those issues will be addressed sensitively on a case-by-case basis. But the direction of travel is clear. Cases must return to the court building, and the judges must take the lead in making that happen. But that, of course, leads to the second question. What do we keep, what do we discard from the working practices developed during the pandemic? Although we will be returning to court for many hearings to be conducted in person, there will be many other hearings that will continue to be conducted remotely. As the Lord Chief Justice has also made clear, there can be no going back to February 2020. The trend towards hearings by video link, which was in its infancy before the pandemic, has now been accelerated, and we are not going back to the old ways of doing things. When I came to the bar a very long time ago now, I would travel 4 to 5 hours a day, sometimes for just a short directions hearing. The young lawyers of today won't be doing that. And that's just the first stage in a digital revolution, which is going to have a profound impact on the way disputes are resolved over the next few years. But at the same time, the experience of the pandemic has been that a great many remote hearings are not conducted as efficiently, effectively, or fairly as they would be if conducted in person. Not everyone agrees, but the preponderance of the evidence and opinion is that hearings which involve important decisions in proceedings and or the evaluation of credibility are better conducted in person. Within such hearings, there will be many occasions, of course, when evidence will be given remotely. For example, expert evidence. It's difficult to imagine that we'll go back to the days when experts will, as a matter of course, come to the court building. Also, importantly, witnesses, vulnerable witnesses, witnesses in domestic abuse proceedings. There will be many examples of cases where evidence will be given remotely within the context of a hearing that is taking place in court. There's also a growing feeling, in addition to those types of hearing which are better conducted in person, there's also a growing feeling, certainly amongst the judges and I think amongst practitioners as well, that the complex dynamic of negotiation and dispute resolution may be more likely to result in an early settlement of disputes when people are physically in the room. So for HEDRAs and FDRs and IRHs, all those types of hearing, which involve, in addition to what goes on in court, an important process of negotiation and dispute resolution outside court, I think we can expect more of those to be conducted with the parties in the court building than remotely. But of course, there will be many other types of court hearing, including directions hearings and case management hearings, when the default position will be that the hearing is conducted remotely. So that's the direction of travel, but it is subject to 3 very important qualifications. First, in every case, the decision about how the hearing is to be conducted will be a matter for the judge. There will be circumstances raised by the parties which may justify hearings that would normally be remote being heard in person, and vice versa. The categories of circumstances in which a departure from the normal practice will be justified, the categories are not closed. It will be a matter for the judge. And it will vary, no doubt, from area to area. Obviously, the circumstances that apply in rural Cornwall or rural Cumbria are very different from those which may apply in London, Birmingham, and Manchester. And of course, the judge will take into account the personal circumstances of the individuals involved, including medical reasons for wishing not to attend court. But it is going to be a matter for the judge, and I would suggest that other types of personal convenience should not normally be a relevant consideration. Secondly, in the short term, at least, the current exigencies of the court system, which I've already referred to, difficulties of the availability of court buildings and court rooms, problems with staff attendance, shortage of judges, all those factors will probably mean that some hearings continue to be conducted remotely, when the broad criteria I've suggested above would normally suggest they should be heard in person. And we will need to be alert to developments which require a different approach as we go forward. One obvious example being if there was to be a return of the pandemic on a wider scale over the coming months. So that's the second qualification. The third is there continue to be problems with the court estate. We mustn't forget that there were difficulties before the pandemic and problems for litigants coming to court in court buildings. There are issues about the size of court rooms, the size of particularly district judges' courts, conference rooms, ventilation, lifts. It's all very well to have a wonderful court building like the Manchester Civil and Family Justice Centre, but if you've only got a limited number of lifts to get people up and down to the 13th floor, that's going to have an impact on what you can do in the court building. Now, HMCTS has worked very hard at tackling those problems during the pandemic. And of course, there are long-standing difficulties about the quality of court buildings generally, which again, HMCTS is endeavoring to tackle. But if we are asking people to return to court, we need to make sure that the resources are good enough. And that leads to the third issue, which we've been focusing on during the pandemic, and that's well-being. The last 18 months have led to a much greater awareness across the justice system, I would say, but particularly driven by our experience in family justice, of the importance of maintaining focus on the well-being of everyone in the system. And that just means that doesn't just mean those working in the system, but also the litigants going through the system. We've become increasingly aware, haven't we, of the pressures, physical and psychological, on professionals and staff, but more importantly, on the families going through the system. And we need to be sensitive to these as we strive to tackle the backlog going forward. But we have to tackle that backlog. There's a very significant increase in the backlog, in particular in private children's law, and also to a lesser extent in public children's law as well. And we need to tackle that backlog because the pressure on the families and children who are stuck in the system and the potential risk of harm to the children caused by delay are acute. So there are many things we need to do when we're focusing on well-being. Can I just highlight three in closing? First, there's a growing concern that the changes in working practices during the pandemic have allowed some lawyers to take on more work than they can handle in a way which enables them to meet their professional obligations. I've heard that from a lot of lawyers over the last few months. Now, that is not good for the lawyers' health, nor for the quality of their work. And we need to, I would suggest, the professionals need to reflect carefully on what they should do about that. Secondly, it's become increasingly clear that far too much time is being spent after court hearings in drawing up court orders, which include lengthy recitals about what's happened in the court hearing, and sometimes efforts to reopen by email points which have been decided by the judge at the hearing. This traffic in email and discussion after the hearing is involving an inordinate amount of time and runs the risk of undermining the decision-making process and, in an extreme examples, the authority of the court. And this is just one example of how the volume of email traffic about every case is becoming unsustainable. Now, we are looking urgently about how to tackle this problem, and this is something for discussion with the professions and with everybody in the family justice system, because that is having a significant impact on, I would suggest, on the well-being of everybody. And thirdly, we need to maintain a laser-like focus on the well-being of our clients. Many of you will have had a chance to read the research published by the Nuffield Family Justice Observatory over the last 18 months about the impact of remote working and the pandemic more widely on people going through the system. And in some respects, the picture the observatory has painted is pretty bleak. Parties find court proceedings, always find court proceedings challenging. And there are many examples, too many examples in the Nuffield's research of litigants finding proceedings to be bewildering, distressing, and traumatic, adding to the traumas of what they're going through with the crises in their family lives. So that means, so far as I'm concerned, in my view, litigants and lawyers need to be together during a court hearing, which has just not been possible during the pandemic. But what about litigants in person? Well, no litigant should be expected to go through such an experience unsupported, experience of having important decisions taken about their own family without any support. So that's why support through court is so important and needs to be nurtured and expanded. And it's why I've been very happy to give it my support today by attending and taking part in this seminar. Now, perhaps some of the things that I've said will be a matter for discussion or debate or controversy, and I look forward to answering some questions at the end. Thank you very much. Thank
you so much, Jonathan, for helping us to understand what your focus is with recovering through in the courts post-lockdown, and I am very pleased to hear about the emphasis on well-being for both the lawyers and our clients. We will next hear from Antonia Felix. Antonia is a solicitor and a legal director in the family department of Mischon Reya. She specialises in all aspects of family law, and the focus of Antonia's focus today will be a solicitor's perspective working in the pandemic, and she will focus not only on the challenges that she has faced, but also what has worked well. So Antonia, over to you.
Thank you. I just want to make sure you can hear me before I start.
Yes, we can.
What a speech to follow on from, and some of what Lord Justice Baker touched on is very much what we experience as solicitors on the other side. And I was thinking I said I would think of lots of positives, but it has been a bit of a struggle to come up with all the positive experiences that solicitors have had. But and obviously the starting point was March 2020, when we all left the office and thought we would be back after Easter. And at that point had no idea what would happen. And when it was discussed that the court hearings would be heard remotely, we just couldn't fathom how that would actually work in practice. And we were very wary, to say the least. But to be fair, within weeks, we were sharing stories of hearings and between different firms and colleagues, and looking at what could be changed, but also surprisingly saying that some of them were actually working fine, and it was looking more positive than everyone thought. I think it then went slightly backwards in that there was more of a backlog, and the issues became worse as more hearings were being done remotely. And so it's good to hear that recently we've just been told that now the judges are going to be sitting back in court. And I know at the Central Family Court in Holborn, they're working to introduce more attended hearings, which I think is going to be a really, really good thing. I think also a good thing is that they've kept some hearings that aren't required, you don't need to be in person, to be remote, such as directions hearings, which I think saves time and money for all parties and can often take out the animosity between the parties if they're just doing the kind of logistics online. So that is definitely a positive. As also has just been mentioned, we've all, as solicitors, been trying to focus a lot more on our mental health so that we can in turn be better solicitors and support the families that we're working for, which can only be a good thing. I read somewhere when I was researching for this speech that Resolution did a survey that found that 51% of family practitioners that were interviewed had actually considered leaving the profession at some point in the last 3 years due to concerns over their own well-being. And that was quite stark to me. My firm where I work, there's been a big push on training us to learn about conflict and boundaries and look at our own mental well-being. And that has actually been a huge help to us. And I think in turn that makes us better able to act up for our clients and to support them when they need us. I think everyone, as a solicitor, if you have the right technology at home, working from home was a positive experience. Obviously not even going to touch on homeschool and having children and childcare issues and toddlers running around. But in general, we were very lucky compared to a lot of people during the pandemic to be able to work at home. And I think we all realise that. But unfortunately, the downside to that for solicitors has been that, again, touched on just now, is that actually working hours have possibly got longer and boundaries and times for calls have slipped, and you find yourself doing evening calls, whereas before you would never have done that. And I definitely think that the work-life balance has all but disappeared since the pandemic, and it's something that everyone needs to work on, because actually I don't think you give your best advice later in the evening and when you've been sitting at your desk, possibly on Teams or Zoom's calls all day for 8 or 9 hours. And I do think that's something that needs to be looked at. The positives from COVID were also that it accelerated parts of the court system which needed a bit of a push, like, for example, the video hearings and the technology that it possibly didn't have before, which I think was very good, and also getting through some of the cases that possibly wouldn't have been heard because it would have taken them longer. The new portal has also, it was in existence, but it's been accelerated, and now everyone has to use it, but many couples are electing to deal with their divorce online via the portal without using a solicitor, which I'm sure is where they need support through court to help them. The court has streamlined the process to pave the way for the no-fault divorce that will be implemented from 6th of April 2022. And this is a step in the right direction, and I think is a good move for litigants in person who, once they've grappled with how to use the portal, can actually be in control of their own paperwork. Again, research shows that I think 70% of applications are now submitted on the online portal, and this is music to solicitors' ears. Staff are returning fewer than 1% of online applications, whereas I think on paper it was about 20%, and that used to really delay the divorce petition and the divorce suit process, because paperwork was being sent back and it was taking weeks to get it back into the court pile to be looked at. And it means that if an individual does have a solicitor, the solicitor can focus on the important part of their case to do with children or the financial arrangements, rather than be worrying about the kind of logistical nightmare of the divorce paperwork. However, there have been teething problems because the platform was originally designed for litigants in person, and it's been added to help solicitors. And there have been a few issues, like, for example, you can't change the the solicitor's name who's dealing with the case. And if you do, then it can crash and not work. And if a litigant in person wants to change during the process to have a solicitor represent them, it automatically moves to paper applications and doesn't stay on the platform. I think it's been rectified now, but it used to be that you could see the other party's drafts on the system. You can't actually see the drafts now, but I think you can still see that there were drafts and possibly the date that they were made. And obviously, if you're trying to keep confidential when you first started the process, that's not ideal for any party. So there've definitely been a few issues, and I think they're working to try to deal with them, but it's going to take a while, I imagine, because there are some. But the very, very positive side of it is that applications are being dealt with a lot more quickly online. I had a decree nisi application pronounced within days, whereas last year, before the portal was used, I was waiting 4 or 5 months for a client to get their decree nisi pronounced. And I've also had consent orders back within 2 or 3 weeks. And again, some stories last year of them taking months and months and months. So that really is good progress. And it means that parties are hopefully getting through the system a bit quicker on that side. And hopefully that will continue with more and more people using it. Another positive for us, at least, is that we can lodge paperwork electronically, and hopefully that's easier for the judges as well, and even for litigants in person, provided they've got the technology to do it, PDF docs and scanners, etc. It's much easier to know that your bundle is with the right people, and you don't have to take in pages and pages with you to court and worry that copies have been lost and do a quick dash to the photocopier somewhere on the floor in the central family court or wherever you are to copy it. So I think that's a real positive, and I know that as solicitors we found that easier, and it's easier to instruct barristers as well because you've got the paperwork there. There have been some horror stories of the online portal, such as the wrong paperwork being posted to the wrong parties and confidential information being disclosed and pensions not being dealt with properly. And I hope that that will filter out eventually, as long as we keep feeding it back. Just touching very briefly before I know I've got to move on to life as a solicitor, now that we're working from home more, it's harder to train trainees and to supervise junior associates because we're just not in the office as much. We have thought of new ways of doing it, but ultimately nothing can be replaced by learning through listening to someone you share a room with, advise someone, and going to face-to-face meetings. I don't think being a family lawyer was supposed to be remote. When you're hearing about someone's, troubled background or the things that they're experiencing and they need a tissue and you're doing it remotely, it's very difficult to feel that you're supporting them. And I know that lots of solicitors have struggled with that, as have the juniors and the trainees. And hopefully we're all coming back into the office more and that will improve. But we do worry that there's a couple of years now where there's going to be real information missing in their learning, in the progress that they make. And we get less interaction with barristers now because often our conferences with them are remote, which obviously is a good thing in terms of timings and less travel, but possibly clients are missing out on the face-to-face experience. And I think Alexis, Campbell, QC will be touching on this in terms of private FDRs, but if it's done remotely, I don't know whether actually people aren't settling as quickly because they're just not getting that face-to-face feeling of negotiating in person. And I think everyone will have different views on that. And then one last thing is also life has changed for solicitors, and that we used to sit in court all day waiting to be heard. And now obviously most of the time we're at home or we're in the office dialing in remotely. So our days have changed and we can do more. And I think clients get more value for money. But I also think some people who want their day in court are losing that experience, just logging in from work or home. So I think, again, people have had different experience on both sides. And just drawing to a close because I'm running out of time. Hopefully we can work on everything we've learned to try and change things for the future and give people proper support, and people will have more access to justice. And I know that what Carmen and her team are doing is helping that. So I'm just delighted to have been able to talk today. Thank you.
Thanks so much, Antonia. I'm so pleased to hear you find and share with us some of the positives, because so often all we hear about is the doom and gloom. And thank you also for reminding us the power of connection and how important it is for our clients to see us in person. We now turn to Amy Slingo, who is a barrister at 4 Brick Court. Amy practices in all areas of family law, both public and private law. She will be talking to us this morning, focusing on her experience of care proceedings, looking at the advantages and some of the challenges of working remotely. So Amy, over to you.
Thank you, Barbara. Just to check firstly, you can hear me okay?
I can.
Great. Yes, I'll be talking about care proceedings and the impact remote working has had on clients in care proceedings, particularly parents. As Antonia said, I think when we went into lockdown in March 2020, it was difficult to fathom how care proceedings could take place remotely. And it was quite impressive, really, how after some initial teething problems, how quickly a relatively workable system was put into place. However, there have been some very significant challenges for care clients in particular working remotely. So both from a practical perspective and a more sort of fundamental perspective, practically speaking, parents in care proceedings often don't have the right equipment to properly participate in the hearing. We're dealing with people who sometimes don't even have a working mobile phone. Never mind another piece of equipment such as a laptop or an iPad, or indeed a reliable internet connection. So this has often caused delays to hearing starting. It's caused significant additional stress for the parents. And most crucially, it prevents them from being able to access the hearing as fully as possible. I think probably the majority of the hearings I've done, at least one of the parents has ended up having to join by telephone rather than video, which obviously means they can not then see the people on the screen or be seen by the judge and the other parties. Another practical problem is that clients in care proceedings often don't have a private, quiet place from which they can join the hearing. It's often hard enough for lawyers to find one, never mind parents who are sometimes living in quite chaotic circumstances, such as shared accommodation, refuges, or if they've got young children at home who they're having to try and keep out of the room during the hearing. In addition to the practical difficulties, I've found that there's also some quite fundamental difficulties working remotely when you're trying to communicate with clients like this. And I know Antonia touched on it with her own types of clients, but for care clients, it's, if anything, even more difficult to build up a relationship and take instructions and give advice to them over the telephone. We're normally dealing with clients with particular vulnerabilities, such as mental health difficulties, sometimes learning difficulties, communication difficulties, or just sort of a general difficulty in trusting professionals. And so I found that trying to speak to such clients on the phone, particularly when you've never spoken to them before at a hearing, it is a very poor replacement to being able to meet with them face to face and take their instructions. And this is sort of further compounded by the fact that obviously in care proceedings, very serious and sensitive issues are having to be discussed, and by the enormity of the decisions that are being made by judges. And so I think having to work remotely for the last year and a half has made me really appreciate how vital in-person meetings are, particularly when you're dealing with parents in care proceedings. In addition to that, I do think there is something uncomfortable about judges making decisions to remove people's children from their care, sometimes permanently if they're making orders for a child to be adopted over a video link. And I know a lot of people have concerns about this and how it's somehow dehumanizing the process. And I remember a judge saying quite early on in the lockdown in one of my cases that he just did not feel comfortable doing it remotely, and he felt it's very important that he's able to speak to a parent face to face and look them in the eye when he's explaining why he's making the decision to remove their child. And I think a year and a half on, we've perhaps become slightly desensitized to some of the problems of remote working as we've become more used to it and time has gone by. But moving on to how we can move forwards, and it's right that care proceedings, there does seem to be more of a steady shift back now towards in-person hearings. And the Central Family Court recently issued some guidance on return to in-person hearings for all types of hearing, apart from case management hearings and very urgent matters, albeit there isn't yet a sort of uniform approach across all court centres. But personally, it's certainly something that I welcome, and I know a lot of people will welcome. There are some quite important things I think we can learn from remote working going forwards to improve the system. And 3 things in particular I'll touch on. I think as the Central Family Court have recognised, that there does seem to be a way of doing case management and directions hearings remotely, and a lot of court time and practitioners' time can be saved by doing it this way. Another problem previously was the actual court space and difficulty in getting conference rooms and things. If you were going to court in person, you basically had to camp out overnight at some courts in order to get a conference room. But hopefully having less hearings in person should help to resolve that problem and also to enable people to manage their time better. Secondly, I think there's a benefit to being more specific about hearing start times. In the past, before the pandemic, care proceedings were always listed at either 10 in the morning or 2 in the afternoon, no matter how many other things were on the list. So you would often be spending a lot of time sitting in grimy conference rooms, waiting for your hearing to start because other things were in the list and clogging it up. Whereas when we've been working remotely, we've always been given a specific start time, which makes things a lot more efficient. And doing it remotely, it does seem to have worked. So hopefully this is also something that can be brought forward as we go back into courts at doing in-person hearings more frequently. As again, it encourages more efficient working and helps people manage their time better and is obviously better for well-being as well. And thirdly, having some more flexibility around remote attendance, I think will be very helpful going forwards. Before the pandemic, in care proceedings at least, there was certainly very limited technology. Being able to set up a video link was almost impossible. If you asked a court usher to do that, it was almost like you were asking them to crack the Da Vinci Code. I remember doing a final hearing when a witness couldn't get to court, and I had to get them up on WhatsApp video on my mobile phone and just pass it round the judge and the bench, as a link couldn't be set up. But now, obviously, everyone is very used to using technology and it's been properly implemented in the courtrooms. So it should be much easier for parties and witnesses to attend remotely if they need to. And so I know I'm running out of time now. So just to sum up, really, I think there are some very important things to be learned from remote working going forwards in care proceedings, as well as hopefully a renewed appreciation for the importance of in-person work in this field, especially when you're representing the most vulnerable clients.
Thank you, Amy. Yes, the challenges, especially in your field of work, are plain and obvious, but good to hear that there are parts of the remote working that we can certainly take with us going forward to make the system just generally more efficient for us and, more importantly, our clients. I now call on Alexis Campbell, QC, to speak to us. Alexis, together with Nicholas Allen, QC, are joint heads of chambers of 29 Bedford Row. Alexis has specialised in divorce and matrimonial financial claims for over 30 years. Sorry, Alexis, for that reminder. And the backbone of her work is complex financial remedy cases, and she has a reputation of being a tough negotiator and managing cases constructively. Alexis is going to talk to us about the development of private FDRs and the so-called privatisation of the family court. Alexis.
Thank you very much, Barbara. Well, good morning to you all. It's lovely to see you here. I was going to end about technology. I'm actually going to start with technology because I was supposed to be speaking first, but had a crisis in my technology, which I won't bore you with. But I think the one lesson I've learned, and the one thing that I can say to all of you, is your Wi-Fi is essential. So the equipment, the platform, Wi-Fi is really the key. I was sat as a judge as well as a practitioner, and in public and private law, and seeing that the people involved in the litigation can actually be seen and heard. Wi-Fi is everything, so we really do need to get the country connected. But that's my finish. I'll start where I intended to start now. And that's, I appreciate we're a mixed audience, so some lawyers and some non-lawyers, litigators and others. I'm going to explain very briefly about FDRs so that everybody knows what I'm talking about. When you have a financial remedy claim, it goes through a series of stages before you end up at a final hearing. And judges make quite a lot of effort to ensure that you don't get to final hearing. And the main way to do that is through a financial dispute resolution hearing. And that means about halfway through the process, once all the disclosures in and you've explained what your finances are, you have a hearing in front of the judge, and the judge gives you an early neutral evaluation of the case and gives you an idea of what is likely to happen if you don't come to a compromise. And both parties are invited to make a presentation to the judge and to try and persuade the judge about which of their cases is best. And the judge gives an early neutral evaluation, and that's called a financial dispute resolution hearing, FDRs is what we call them. They're really important because statistics show us that about 80% of financial remedy claims settle on or around this FDR appointment. And of course, it saves a great deal of turmoil and costs if the parties can come to a settlement in advance. So it was a really important part of our armory as judges and as advocates in getting the case ready without too much cost. When the pandemic closed all of the courts, there was a massive shift in trying to rationalise the very limited court time available. And initially, at the very beginning, most FDRs were just cancelled or postponed. And in that void, what happened was a practice that had begun to start before COVID, but then really took on a great pace, were private FDRs. And essentially, the parties, generally through their solicitors, would pick a judge, a senior practitioner who was experienced in financial remedy claims. And they would each pick a judge between them. Generally, what happened was both sides would pick 3 judges, and then between them, they would select one they were both happy with. That judge would be given the papers sometime in advance of the hearing, and the judge is then privately engaged to set up this early neutral evaluation hearing. Generally, they were all done remotely, so just as we are now on Zoom or some other platform. The advocates would prepare a document setting out their case. That would each advocate would send that to the judge. The judge would get his papers at least a day or two in advance. And the judge was paid by the parties to sit there for the day and evaluate their case. Now, this being a free market, what tends to happen is that judges obviously want to get more work. So it's very important that they do the best they can and give truly a fair, early, neutral evaluation. And because they want more work, they read the papers carefully, they really consider the case beforehand, and they want to give what is the best opportunity for the litigants to try and settle their case. Now, when you've been through a court process doing this, most of the judges who deal with these cases are extremely experienced. They know how to deal with the case and they get on with it well. But often what happens in busy courts are that the judges are given too many cases to deal with in one time. So you may have a judge who might have 3, possibly 4 FDRs. I've had days where I've had up to 6 FDRs to do in one day. And with all the best will in the world, it's very difficult to give the time and attention that's necessary to at least 3 cases. And often, sometimes, there are decisions that have to be made, which judges will perhaps try and find a compromise by parties. And often, FDRs can be quite difficult environments to try and settle. In my experience, you can sometimes get a bit of rough justice, where judges press the parties to perhaps meet in the middle and not always giving them the early neutral evaluation that the parties perhaps deserve. What I found with private FDRs, and I think this is shared by a lot of my colleagues, is that the judge has the time to consider the papers properly in advance, because that's what the case warrants, and can then give the early neutral evaluation that the case deserves. And I've seen over the last 18 months that these private FDRs have got better and better. And I'm pleased to say that we're now getting to the stage of the really experienced judges that we see in the financial remedy courts. What's the difference about doing it remotely? Again, this is partly anecdotal, but I think shared by a lot of my colleagues. When you're in court, you tend to get a lot of bluster. You tend to get a lot of high drama and personalities imposing their case. And often it can get fairly exciting. And as an advocate, it's a very adrenaline-filled day. As a litigant, my impression is that it's obviously a very stressful day. When you're in court, it might be the first time you're facing your ex-spouse. You're being asked to make decisions, sometimes at speed, with a lot of pressure on you. When you're remote, you're not in the court building, you're not in the same room as your ex-spouse, and that can, for a lot of people, be a real saving grace, not to actually have to sit there and face your ex-partner across a sometimes very small district judge's courtroom. When it's remote, though, one of the benefits I've seen, which I think is shared by many, is that some of that bluster, some of that high drama, some of that courtroom fighting is taken away. And that's probably a good thing. Although it may not feel as dramatic, it might not feel like an episode of Suits on the TV, but what you're actually getting is issues being presented to the court, sensible issues that matter, in a more calm environment. And it's amazing what the mute button does. You can actually have an advocate speak to the judge uninterrupted in clear and simple terms with everybody listening. And if you have a quiet space, and I couldn't agree more with Amy, it does depend on you having, as I've said, good Wi-Fi and a quiet space. But if you have that, this can be a much more measured, calm process. So there aren't the same antics as you'd often get in the courtroom. Also, really importantly, what happens at an FDR is that the parties exchange offers. And sometimes when you're in court, when there's a lot of toing and froing, those offers can get confused. My experience of the remote FDRs is that the offers are clear and concise. Generally, the people litigating, so whether you're in person or whether you're represented by advocates, exchange offers by email. What tends to happen are the offers are reduced to bullet points. It's much easier to see when you're apart if there are a short list of bullet points about the main issues. You tend to get a lot less confusion, and the big issues are apparent straight away. And that enables you to focus on those issues. And because when it's a private FDR, you have the judge there all day, you can go back to the judge on a specific issue and say, in terms, Judge, you gave us an early evaluation of this case. You said that there was an issue, and we've come up with this scenario. Do you think that's fair? And you can get some proper feedback. So the remote experience in my practice has been very positive. I think there are some negatives we've got to be careful of. One is it's very easy to walk away. Both litigants and their representatives can simply say, no, we don't like it, and that's too easy. There was a case given a judgment by Mr. Justice Most in AS and CS very recently, which has made provision for judges to impose private FDRs. So you can't not turn up, you have to be there. But sometimes it's quite easy not to engage if you're not sitting looking at a judge with the judge staring at you across the bench. And I think that that's one of the difficulties, particularly for litigants who are in person or litigants who haven't had a great deal of court experience. There is something about being in the building with the judge looking at you, with all the pressure of everybody there, that encourages you to settle. What's the answer? Well, in my view, the hybrid. I think remote FDRs are an excellent arrangement, but I think the fact that the litigants don't get the same support, the fact that it is easy to walk away, that can be countered by having remote teams. So you can be there with your advocate in front of the screen, but you and your lawyers, whether it's solicitors or advocates, barristers, to be together in a room. That way, if there's any confusion, you can have the difficulties explained. And if you need support, and we all do through these difficult days, and they're more likely to settle if you can actually turn around and say to your advocate, what does this mean and what should I be doing? And if you're a litigant in person, those private FDRs can be very useful because it is informal and you can ask the judge for a specific guidance or for an explanation. FDRs, in my experience, have been a significant change in financial remedy claims. They're a really important part of our armoury. Remote FDRs are not a bad thing. We just need to manage them properly. And if you find the remote experience literally too remote, then find a hybrid where you can get together with your team in a conference room and work together. And just echoing very quickly what Amy said, I think the best thing that we can try and develop if we can is this access to courts with times, flexible times. I know in the criminal courts you have a tendency where you'll be listed not before 11 or not before 12. And I think if we could do something like that, so that if we weren't in the building, we could use our time more flexibly, I think that's something worth developing. Anyway, I think I've gone over time, so I'm going to stop talking and hand back to Barbara. Thank you.
Thanks, Alexis. No, you're right on it. So thank you for that. And thank you again for the reminder that one size can't fit all in this world of ours, and that for the reasons that Amy said, doesn't always suit a care client being remote. It might well suit a client in financial remedy proceedings. And as Lord Justice Baker said, how important it is for the decision as to whether it's remote or not to be judge-led, so that we get the right cases in the right forums. Last but definitely not least, we're going to hear from Sarah Fairweather. Sarah will be speaking to us from the coalface, as it were, because she is the service manager of the Leeds Support Through Court unit. Sarah is passionate about the not-for-profit sector, and has worked for Land Aid, the Institute of Fundraising, and as I say, she's currently the service manager from Leeds. So Sarah, welcome.
Hello everyone, hopefully you can all hear me, and thank you Barbara for that lovely introduction. I'll carry on, but do let me know if anyone can't hear me. So yes, I've been at Support Through Court for nearly 4 years now. I'm the service manager at the Leeds office. And today I'm just going to talk a little bit about how our service has had to change and adapt during the pandemic. Like everyone else, we had to kind of close our doors 20 months ago. So in March 2020, we had to completely close. We were an entirely face-to-face service at that time, and we had to very quickly change and offer our service to our clients entirely remotely. By the summer of 2020, we were able to return to the office again and offer in-person appointments. We did this by completely changing our office layout. We were able to maintain social distancing by reducing the number of clients and volunteers we had in the office. We again had to close in November 2020, but we've been consistently open since April of this year, offering so we're offering in-person appointments, but also we're helping people by Zoom, remotely, by telephone, and we're offering as much support as possible by email as well. And this gives our clients more options. We're able to also help people further afield. So we've really had to sort of change our service, and those are the positives that we found. The way that we provide our service at Leeds, I have 60 volunteers, some are law students and some are retired professionals. And we help litigants in person. We can also attend remote hearings with them. We offer them plenty of information, and we can signpost them to other services as well. In my 4 years at Support Through Court, I've always observed that litigants in person have struggled to follow court procedures, but that struggle only increases when they have other obstacles, like you know, English not being their first language. They may have learning disabilities, and then the process becomes even that much more difficult for them. We're there to help them. But what we have found over the last 20 months is that with things like remote hearings, that has complicated the process for litigants in person further. I wanted to now tell you a case about a client that we recently helped, and I felt that this demonstrated well how we've been able to adapt our service to help clients going through remote proceedings. So this client that we helped, let's call her Zoe. English was her second language. She'd only moved to the UK 2 years ago with her young daughter. Zoe had received a huge pile of paperwork from the court, and she didn't understand any of it, and she struggled to read it. So we quickly booked Zoe an in-person appointment because she had contacted us by phone. She came into the office, we were able to look at her paperwork, and we understood that her ex-partner, who had been abusive during their relationship, had started a child arrangements proceedings. Zoe could not access legal aid and she couldn't afford representation. So we were able to explain to Zoe what a remote hearing would entail, because we worked out through the paperwork she'd received that there would be a remote hearing in 4 days' time, which Zoe wasn't aware of. So we explained the process of what would happen. We were able to also arrange a free interpreter for Zoe to attend the remote hearing with her. We were also able to arrange for a volunteer to attend with her and take some notes, and that volunteer was able to explain before and give her a call beforehand, before the hearing. They were able to also help her after the hearing, so they went through any questions she had. And this was hugely helpful for Zoe. She told us that she would not be able to have attended this remote hearing without our help. And we're still helping Zoe now. She has a follow-up hearing soon. And as I said, she's told us that the help we've given her has been invaluable. So I hope that story has given you some insight into how we help litigants in person and how we help them deal with some of the challenges they face at the moment with remote hearings. What I'd say is, if you do want to hear more about how we help people and how you can support us, please do support our social media channels. And if you come across anyone you think that might be able to benefit from our service, please do refer them to us. But I think I've gone over time as well, so I'm going to wrap up now, but thank you all for listening.
Thank you so much, Sarah, for that view from the coalface. Having heard all the speakers, it seems to me safe to say that the impact of the COVID-19 pandemic on the administration of justice has been dramatic. It has caused most processes to move online. And it seems to me that as we emerge from this, there will be no return to the pre-COVID. There will be a mix of working practices, which we very much hope will be of benefit to all. So we now move to the Q&A part of today's seminar. Lots and lots of questions have been posted. May I start with one that has come from Nigel Shepherd? It has been reported that the Central Family Court will now no longer take counsel's availability into account when listing hearings. If this is the case, it appears to be a development that has been introduced without advance notice, much less consultation. Is the panel able to confirm or deny the same? And if so, what comment, if any, do you have on the emotional and financial impact on litigants if they have to change counsel? May I start with you, Lord Justice Baker?
Yes, well, one of the advantages of conducting events like this, and of course, it's not something that one would do if one was in court, is that one can scan one's emails at the same time. I promise you, one doesn't do that if you're judging. You listen with rapt attention to everything that counsel is and the advocates are saying. But it so happens that this very issue has been the matter of discussion by, I won't say who, but a number of senior judges this morning. I emailed, and I know the president is going to be dealing with it very shortly. So, Nigel, the answer to your question is watch this space, or not. Don't watch this space, but listen out to what the president says, because it's a very sensitive issue, and I think I could pass my own views out to you, but I think I'd rather wait till the president has a chance to reflect and say exactly what he wants to say about it.
Thank you.
I think that the availability of representatives has always been a factor. The traditional rule it's always been a factor to take counsel's availability and the convenience of lawyers into account, but it's never been ultimately the decisive factor. Now, that's been the traditional rule. Barbara will back me up if she thinks I've gone too far on that. Whether whether the president wants to say more about that, he's going to be thinking about that in the next few days, and you'll hear more about that in due course.
Thank you very much. I agree with you with what you've said about council's availability. I think the point also is that there's a real concern that that will have an impact on litigants. So obviously that will also be.
What I would say, can I just say one other thing about it? I did talk about my concern that lawyers were taking on too much work. I did say that as part of my anxieties. It's been possible for lawyers to take on more and more work in the pandemic because of the way remote working works. I think that when talking about counsel's availability, we need to, and solicitors too, we need to reflect on the extent to which it's okay now to take on quite as much work as you've been doing so far for all sorts of reasons, to do with the quality of the work, not to say your health. I think we need to reflect on whether we need to just take a step back from what's been happening in the pandemic. Again, I'd be interested to know if any of the lawyers agree or disagree with what I've just said.
I know certainly from my experience, when you get to final hearings, particularly in money cases where they can be quite complicated, you will find that a lot of litigants would be very, very stretched to present their cases and their own evidence fairly if they didn't feel that they had the same advocate representing them.
Yeah,
you tend to go through, as with any final hearings, a long process of getting there. But in interim hearings, far too often counsel's availability becomes an issue, and it shouldn't even matter. Interim hearings are directions straightforward. I think from a financial perspective, FDRs and final hearings obviously require the same advocate. But other than that, I couldn't agree more. Counsel's availability can hinder the progress of the trial, and delay can be as prejudicial as not having the same counsel. So there is a balance.
Yes, I agree. And I think a sort of an emerging theme is that one size doesn't fit all. It depends on the type of case you're dealing with, because clients get weary having to repeat their, in quotes, story to a number of counsel. Yeah. That has to be borne in mind, obviously. Let me move on. And actually, can I come to you again, Lord Justice Baker? What safeguards, an anonymous attendee is asking, what safeguards will be put in place to ensure confidentiality of documents and access to Teams calls or Zoom? They are concerned that there might be a real risk that hearings could be interfered with.
You mean if I got this right, on remote hearings, there's a concern about the breach of confidentiality of documents?
Yes, documents going into the wrong.
Well, that is not a factor which has received much prominence in the discussion I've heard, and I'd be very interested to know whether the practitioners think it is a significant problem. Is it more of a problem with remote hearings than it is at other times? I can see that it might be, but I'd like to know what the practitioners think, actually. Sorry to pass the buck.
I haven't found it so, because most of the time, those who ought not to have access to the entire bundle need only rely on their own statement, I have found. And so there hasn't been, in fact, in court, they would have much more access to it just sitting there with the bundle in front of them. So I haven't found it a particular problem. Alexis, have you?
No, I haven't actually, not any direct experience. I think there is a problem though, perception of a problem. It's very easy, isn't it, to forward a bundle just with the press of a button. Yes. It's much harder to photocopy 2,000 pages and hand them to someone. Yeah. And I think I have had a remote, slightly different experience where I've had third parties in the room unknowingly listening to.
Yes.
Yeah, that's much more of an issue.
I agree.
And although there's always a warning, the judges and the clerks always give a warning, and as advocates, we always tell our clients to make sure. But I conducted, or I was an advocate in an FDR, and noticed that the wife had a foot sticking out from the side of the desk, which turned out to be her partner who was giving her information. So, yeah. I mean, anecdotally, there are worries about it, but obviously it's a contempt of court, so there are serious repercussions.
I imagine that solicitors have rules about this, which have been perhaps tweaked in the pandemic. Is that right, Antonia?
Well, yeah. So if we have hearings, for example, in the office or at home, which we always say to the client to have the camera in a way that makes people feel comfortable about who's in the room. And we say, but just like the others have said, I've had an experience where someone's dialed into a hearing and said that their camera's not working. And then they've given evidence, because it was all last minute and nothing could be adjourned. And they've given evidence and spoken with their camera off. And my client was worried that they had someone in the room. And there have been a few issues like that. But obviously, as we all know, we have to be, no one else can be in the room and it's confidential. So that's what we do. And often I find going to the office makes people feel more comfortable, because then they know who's in the room.
What about the documents point the questioner asked? Have you had to change your practice with documents and remote hearings?
No, but again, we have rules within my firm, being careful who you send it to and checking the email addresses and copying in people that shouldn't be copied, because there've been a few people copied in on replies. But generally we haven't, because we haven't had any issues. But the bundles are very big, and in one respect, I think it's harder to check bundles when they're online and not actually in front of you, in terms of other documents slipping in and confidentiality issues. So I'm sure there have been issues, but I haven't personally had any.
Amy, anything to add?
Yeah, I think certainly people attending hearings who shouldn't be is definitely a problem in care proceedings, especially, as I was saying, parents often aren't able to join on the camera. So you're really just relying on their word that no one else is there. And they don't always understand how important that is, even though it is explained to them. So I've definitely had hearings where you've been concerned someone else might be listening in. And also they don't always have a private place to go to anyway, so it makes it more difficult. With the documents point, I think probably we were moving towards a more paperless practice regardless of the pandemic. So that's probably something that would have arisen anyway. I don't think I've really noticed there being a problem with people getting documents who shouldn't have them. And yeah, I think that was probably where we were moving to anyway, even if we'd continued doing in-person hearings.
Sure. And Sarah, have you had any of the people you're working with complain about this?
We have, yes. So we've supported remote hearings, and the other side had a friend or family just in them with the hearing, and the judges asked them to leave the room. And I think there is a lack of understanding of the rules. I think, especially in terms of litigants in person, they just receive the MS Teams link and they think, oh, I can have, my friend attend with me and listen in. So we have experienced that.
Thank you. I'm going to move on to a question that's been asked by Sarah McElroy. Whilst I appreciate that many of Alexis' points about private FDRs, many litigants in person can't afford them, and while some choose to be in person, they can't afford legal representation. The cost of the judge alone for the day is often thousands of pounds. How can litigants in person harness the benefits of private FDRs, such as extra time from the judge, that are not possible in mainstream court hearings? So I guess that's you, Alexis.
I'm afraid I walked into that, and it's a good question. It's really important. The simple direct answer is that if a lot of other cases are taken out of the list and are being dealt with as private FDRs, that releases some pressure on the system. It is not necessarily an adequate answer, though, because that does risk there being a sort of two-tier system of justice, which is something that I wanted to touch on. Are we privatising the courts for those who can afford to pay for a judge? And is that fair? Is it right? It's obviously a really important issue. I think there are some other options, though. I don't know that these have been explored, but they are worth exploring, and certainly something that maybe us at the bar need to think about. There are specialist practitioners who deal just in financial remedy, and some of them would be prepared, I'm sure, to do pro bono work. I'm not sure how it would work in terms of insurance, because it would need to be by way of direct access. But at the moment, there are a number of barristers, most barristers in the specialist sector do pro bono work, where they come to court and represent, or they assist judges in helping litigants in person. I've done it for many years. I know most of my colleagues have. It would be possible to organise a system where you have barristers who are available to do private FDRs. it would have to require careful preparation. You couldn't impose on time if you weren't preparing proper bundles, so it would require some level of organisation. And I think particularly in cases that were relatively straightforward, an early neutral evaluation in a calm, more relaxed setting would be very useful. In my experience, the problem with mediation is that mediators, by virtue of the skill, aren't supposed to advise, they're supposed to enable the participants to come together at a compromise. With an early neutral evaluation, you are giving advance warning of what a judge is likely to do. And for litigants in person, that's probably one of the most valuable aspects of the proceedings, if they can have early on somebody independent say to them, in my opinion, this is the way the case is likely to go. The more complicated the cases get, the more papers are involved, the more difficult it is to ask for that to be done on a pro bono basis. Before long, you end up in a situation where you are, as with an ordinary court-based FDR, one busy judge trying to deal with papers, and it's physically impossible to give the attention that the private FDR gives. So it might be possible that there is a filtering system for simple cases early on after the filing of Form Z, where you could come in and the judge might be able to say, a private judge or even a court-based judge, this is the way your case looks, and at this early stage, my evaluation would be X. So I think there is scope for it, and there are, as I've said, many specialist barristers who want court experience, who want to be able to give back to the system that we work in. They're very generous, a lot of the barristers that I work with. So it is not outside the wit of man to organise. So perhaps I'm setting myself a challenge here. I should stop talking.
Alexis, thank you for that. And I think that it's a worthwhile challenge that you set yourself, because I can see that if you worked together with experienced mediators, you could cut through some of this. Part of the difficulty often I find, especially with my mediation clients, is that they haven't understood what the spectrum of likely order is. And so they have unrealistic views about what is achievable. But if you had a system where an experienced practitioner told them what was likely to happen, and that was the focus of their attention in discussion in the much less expensive mediation, although not any less robust, one can see how you could help many families to resolve their disputes in a much more affordable way. We have just a few minutes left for our Q&A, and so I think we ought to spend some time on this question. Somebody has asked this: do you have any advice for aspiring family, it says barristers, but I think the same applies to solicitors, who are struggling to access work experience due to the pandemic and hearings moving online or being postponed? So may I start with Antonia, please?
Yeah, that is very difficult. We're still offering as a firm internships and apprenticeships and training contracts and vacation schemes. We did have one or two over the summer where it was a virtual one. So I think my advice would be still to apply to firms or email people directly if you can get their contact details to ask what they might be able to do to help. And I think just keep trying, basically, because things are getting back to normal, and it is available. It's just there's probably more people trying for the places now because there's a catch up. But I know that solicitors do want to give people the experience, and where we can, we will. And I suppose it's just thinking of outside the box of who you can shadow, and as I say, contacting people individually to see whether, even if it was just for a day, whether you could spend time with someone and listening to how they're doing it, subject to confidentiality issues, obviously. But I think it's difficult. I can't think of anything else, really, if anyone else has got anything that they can suggest.
Jonathan, what's the marshalling position up?
I haven't seen many marshals about the place in the last 18 months, but I imagine, with the Lord Chief's direction about judges back to court, I think we'll find that marshalling that we see more marshals. But the other thing to say is, and they're just timely now because they're arriving in a minute, we now have judicial assistants, not only in the Court of Appeal, but also in the Family Division. Obviously, there are only a few places available, but that is another new way in which young people who haven't got pupillage yet are able to experience what it's like in court. I would imagine that mini pupillages are now going to come back. Aren't they in 4PB and Brick Court as well?
Yes. Can you just tell us a little bit about the judicial assistants, what they do, just in case?
Well, the judicial assistants prepare bench memos on the cases in the Court of Appeal and also in the Family Division, and they do a variety of preparatory work. So that's what they do for us. And they might, for example, if I was doing a talk as I'm on adoption, which I am doing later in the week, I might ask my JA to look at the recent cases just to update, so I make sure I haven't missed anything. But they also get a chance to sit in court and watch the advocates and hear the judges talking about the advocates. Again, they have to be sworn to secrecy, Barbara, because in case they don't pass on what we've said. But it's a fascinating experience. I mean, there are only a very few places available. There are 25 in the Court of Appeal and probably 10 in the High Court at the moment. I think there's a scope for expanding that scheme if the funds are available to include judges, local judges, CJs as well, but not happening yet.
Thank you. And what if anything is happening at 29 Bedford Row, Alexis?
We're still taking on pupils and mini pupils. It's just been remote, I'm afraid, but it hasn't held us back. We've taken on 3 new tenants from pupillage during the last 18 months, so it's still working. You just need to apply, certainly to barristers' chambers, for mini pupillage schemes. Go on the websites and apply, and insist on being present during remote hearings. And now, because we're back in chambers, you can come and do them remotely with the barrister from their desk. So I still urge people to go to individual websites. Just to let you know, I've also had an email from a colleague who sits at the CFC, and she tells me that they are accepting dates for counsel, provided that they're given on the day of the hearing, and they can't be sent in later on. So for Nigel, who asked that question, and any other practitioners, at the moment, the CFC are taking dates to avoid if handed in with the order.
Makes sense. Amy, what's happening at 4 Brick Court for aspiring barristers?
Yeah, similar to Alexis, 4 Brick Court is taking mini pupils, and they were throughout the pandemic. I do think there were more barriers. It was more of a sort of faff to get their details and send them to the court ahead of time, to the court clerks. And I seem to find that other parties were more likely to say no to a mini pupil attending the hearing when it was remote, compared to if they were just there at court with you. I suppose it was
why they would say no remotely.
Not really, just sort of their client didn't want mini pupils there, things like that. I think they just, it felt like there was more of a forum for them to say no than if they were actually physically with you at court. And because it was all being done remotely, it was just over email often. So I know that people in chambers had that experience when they were trying to take mini pupils with them on a hearing. But hopefully now things are going back to normal, that will be less of an issue.
Sure. So in answer, it really is business as usual. You just have to try a bit harder and not be put off by the remoteness of the way in which we are working. And Sarah, from the coalface, I know you rely on volunteers anyway. So what's happening in terms of people looking for work experience and so on?
So I think it has been challenging from what I've heard from students who are going on to apply for mini pupillage. Sorry, I couldn't speak then. So it has been challenging from what I've heard, but I don't have much else to add. But I've just heard on the grapevine that they have found it challenging.
Thank you very much, and thank you all. I will now hand over to Carmen to do the closing bits. Thank you, Carmen.
Thank you all so much to everyone that's joined us and bought a ticket and helped us raise funds for Support Through Court and our service. A huge thank you to everybody. Thank you to everyone on our panel. I really, really appreciate you all giving your time to us this morning. Some technical difficulties, which is part and parcel of a virtual event. I'd also like to say, again, a massive thank you to our sponsors, Reya Family Finance, 4PB, and Mischon Reya. Our Family Wizard, as James said earlier, are very kindly hosting a Carry On the Conversation event. So if your question didn't get answered, or you would like to meet some people virtually and keep talking, there's going to be a link coming into the chat in a second. Equally, Support Through Court is a charity, and the only way we're really able to keep helping people like Zoe, who Sarah mentioned, is by relying on the support of organisations and individuals. So please do think if there are other ways that your organisation or as an individual you might want to support us, please do get in touch. We're always really keen to discuss ways that people can support us and how we can share more about our work and to enable our service to be there for litigants in person. So a huge thanks to everybody. I hope you have a lovely day and hopefully see you again next year. So thank you very much.
Thank you, Carmen. Good morning.
Okay, thanks everybody. Bye-bye.
Bye-bye.